fate, and we've seen more than $2 trillion in damage. I have the unfortunate distinction of being the home state attorney general for Purdue Pharma and many of the members of the Sackler family who are responsible for this crisis. And that's why in December of 2018, Connecticut sued Purdue Pharma and the Sacklers. Now, importantly, we focused on the Sacklers for their direct participation in helping to cause the addiction crisis and for telling lies that have made people sick and has gotten them killed. They turbocharged the sales of OxyContin, a molecule very similar, almost identical to heroin. They tell lies about opioids, saying that they're not addictive. They tell lies about victims, saying that their addiction is their fault. They push long-term use. They cover up for doctors who overprescribe, and they cover up for pill mills. They sell lies like pseudo-addiction, where they say that the reason why people get addicted is because they don't have access to enough opioids. And if they just had more drugs, they wouldn't get addicted. And after causing widespread addiction, they attempted to profit off of that addiction by offering therapies to confront addiction and to help people get off of their addiction to OxyContin. And so Connecticut sued the Sacklers, exercising our state's police power to protect the public health and lives of our residents. These claims are essentially identical to those of our sister states. In 2019, the company, Purdue Pharma, declared bankruptcy. But importantly, the Sacklers did not, because they are not bankrupt. No one believes for a second that the Sacklers do not have any money. By conservative estimates, they've taken out at least $11 billion from the sale of OxyContin, and they are growing wealthier by the minute. The Sacklers personally have no basis to seek the protections of the bankruptcy court. If they were bankrupt, then all of their money, all of their assets would be in the control of the bankruptcy court, and the court could decide to distribute those assets to help thousands, if not millions, of victims and their families. Now, even though the Sacklers are not bankrupt, they've used the bankruptcy court to stop states like Connecticut from going after them and holding them accountable. And they want us to agree to a deal in which the Sacklers pay $4.2 billion over 9 years. Now, let me put that in perspective in case $4.2 billion sounds like a lot of money. Over 9 years, if you assume the Sacklers have made at least $11 billion in ill-begotten gains, if they pay $4.2 billion over 9 years, that means they'll pay less than 5% on their money every year. They'll more than cover that 5% on the investment income in their offshore accounts. And not a single one of them will have to sell a house or a boat or a piece of art or jewelry. And if we don't agree, and that's why I'm here today, the Sacklers want the court to force us to accept this deal and to force sovereign states like Connecticut to release our claims against the non-debtor Sacklers. This is an outrage. Connecticut is exercising its sovereign police powers against the Sacklers. No court in this country has ever held that a court may force a sovereign state to release its police power claims against a non-debtor. To permit non-debtors to abuse the bankruptcy process like this is an outrage, and Connecticut strongly encourage you to stop this abuse. Thank you, Mr. Chairman.
Thank you, Mr. Attorney General. I now recognize Ms. Schweigert-Moser for 5 minutes.
Chairman, ranking members.
Just put your microphone on. Thank you.
Thank you. Chairman, ranking member, and distinguished members of the committee, it is a great honor for me to appear in front of you today. My name is Tasha Schweigert-Moser. I am a mother of 3 young children, a wife, an Olympic bronze medalist, and a practicing attorney in corporate law and sports law. I am also one of the hundreds of survivors of sexual abuse at the hands of Larry Nassar, who was the official doctor for USA Gymnastics and the United States Olympic and Paralympic Committee. I dedicated my entire childhood seeking to represent the United States of America at the Olympics. At the age of 15, I made our country's women's gymnastics team for the Sydney 2000 Olympic Games. The team won a bronze medal. Like the Olympic athletes representing our great country in Tokyo right now, my teammates and I had to make huge sacrifices to get there. My sacrifices came at a horrific cost. I was abused by Larry Nassar. At first, Larry gained my trust and confidence. After beating up my body day in and day out in my goal to win for my country, I would see Larry for medical treatment, which gave him the opportunity to do unspeakable things to my body. I saw Larry because he was the only doctor that USA Gymnastics and the Olympic Committee made available to me. I had no choice in medical providers. He was the Olympic gymnastics doctor. Everyone on the national team and the Olympic team saw Larry for medical treatment. When I was part of Team USA at the Sydney Olympics, the Olympic Committee and USA Gymnastics had our gymnastics team stay outside the Olympic Village. With no chaperone present, Larry performed his now infamous medical treatments, sexual abuse on me when I was a child in my own sleeping area. He also sexually abused me at the Sydney 2000 Olympic Games in the actual Olympic Stadium. I relied on USA Gymnastics and the Olympic Committee for my well-being. Both organizations must be held accountable for the abuse that happened to me and the hundreds of other survivor sisters. In 2018, I filed a lawsuit seeking to hold USA Gymnastics and the Olympic Committee accountable for my sex abuse. Shortly after I filed my lawsuit, USA Gymnastics declared bankruptcy. My claim against USA Gymnastics was automatically stayed. I was appointed co-chair of the Sexual Abuse Survivors Committee in the USA Gymnastics bankruptcy. What does the bankruptcy of USA Gymnastics have to do with my independent claims against the Olympic Committee? At first, I thought absolutely nothing. The Olympic Committee had a net worth of approximately $468 million. The Olympic Committee made approximately $79 million per year in profits. After USA Gymnastics bankruptcy, I learned a sad reality that the bankruptcy would hurt my efforts to get relief in our civil justice system for my independent claims against the Olympic Committee. Bankruptcy courts asserted extraordinary powers that I had never thought possible over my claims against the Olympic Committee. The bankruptcy court stayed my claims against the Olympic Committee. When I recently tried to lift the stay so I could continue my lawsuit against the Olympic Committee, USA Gymnastics claims that I had violated the bankruptcy stay. When USA Gymnastics filed a bankruptcy plan, they claimed the bankruptcy court had the extraordinary power to release my sex abuse claims against the Olympic Committee for abuse that happened at the Olympics. How could the bankruptcy court decide my claims against a non-bankrupt, wealthy corporation like the Olympic Committee? I found that bankruptcy laws protect very wealthy organizations like the Olympic Committee who are not in bankruptcy and who have the ability to fully pay for injuries they caused me. This shocked me. I thought it was unfair and unconstitutional. I thought it was unfair because without my consent, a bankruptcy court could take away my claims against an organization that has not declared bankruptcy. I thought it was unconstitutional because the Constitution protects me and all Americans from the government from taking our property without due process and preserves my right to a jury trial. I learned that the bankruptcy court could take away my claim against the Olympic Committee without a jury trial, without my consent, and without the right to opt out of a bankruptcy plan. I had no choice in who provided me medical treatment, which resulted in my sexual abuse, and now I feel I have no choice in this case seeking accountability for that sexual abuse. While bankruptcy should not be the end of the road for sex abuse creditors, in many ways, it has felt like a giant black hole of truth and accountability against non-bankrupt organizations. It has been nearly 3 years since USA Gymnastics declared bankruptcy. The Olympic Committee received substantial protection from the bankruptcy courts, yet has given no relief to me or the other many survivors of their despicable conduct. I support this legislation because each athlete like me who endured this hell and sexual abuse by Olympic doctor Larry Nassar, each athlete deserves the ability to make the choice on how they will seek justice. Victims and survivors of their abuse are then barred from seeking justice and fair compensation in the court of law and deprived of their constitutional right to a jury trial. This bankruptcy abuse must stop, and this is why I support this bill.
Thank you so much. I now recognize Ms. Plus for 5 minutes.
Good morning, and thank you for having me here to testify today. Next week, we'll commemorate the 7th year since I lost my firstborn son, Jeff, to a heroin overdose. The call came from my middle son, Jason, while I was overseeing a concrete pour at Fort Meade. He would only call me during the workday if it was an emergency, so I answered. The signal was weak, there was static, there were concrete trucks and construction noises in the background, so I pushed the phone close to my ear, and I heard him screaming, "Come home, Mom, come home." Jeff was dead. 11 years prior, I was attending Jeff's first football game of his junior year. There was a huddle, a whistle blown, pushing on the line, a circle of players and refs on the field, parents standing trying to see who was down, and then a coach waving to me. I rushed to the field. Jeff was rolling on his back with his knee pulled to his chest, crying in agony. The orthopedics doctor said that if it would take surgery, extensive physical therapy, and Oxycontin to manage Jeff's pain if he ever wanted to play sports again. Oxycontin every 4 hours. Take it even if you don't feel the pain because it'll be important to stay ahead of it, the doctor said. This was 2003. A national crisis was brewing, but we were oblivious. There were no headlines about overdose deaths. There was no education about the addictive qualities of Oxycontin. No one told me that it might be hard for Jeff to stop taking those pills. I glanced at a picture of our family in a frame in our living room the other day. Everyone was smiling normal, but Jeff had a wide open comical smile on his face with his hand propped on his hip. I'll never see his smile again, I thought to myself and instantly folded over in pain. I've been grieving his loss for 7 years, and yet the reality still hits me like this at odd times, like fresh news, like a punch in the gut that makes you want to curl up in a ball on the floor and cry until you can't cry anymore. Jeff's life and story is important to all of those who loved him, but his story alone is not enough to impact laws. I don't expect you to care about him, but the fact that Jeff is among 930,000 other people who have died of an overdose since 1999 certainly should be enough. In 2001, when a federal prosecutor reported 59 Oxycontin overdose deaths in one state, Richard Sackler wrote in an email to Purdue executives, "That's not too bad. It could have been far worse." I grew up in a family of strong women who set an example of voting, working at the polls, running for town boards, and being active members of political committees. My grandmother wrote op-eds from her nursing home bed until she passed. I bring this up to mention that I grew up in a family who believed in our government, in our governmental processes, who taught me that if you wanted change, there were ways to create it, and it is your responsibility. What my family did not teach me is the power of corporations, the rich people who benefit from them, and there are laws that protect them. In 2011, after 1 week of prescription sales doubled Purdue's forecast, Richard Sackler said, "I had hoped for better results." For the rest of America, we have laws in this country to teach personal accountability, no matter how petty a crime is. In fact, we even criminalize the illness of addiction, despite the fact that incarceration increases a person's risk of fatal overdose by 40 times. This massive war on drugs has done nothing other than perpetuate harm, cause massive human loss, and decimate communities of color. I know a Black man sentenced to 6 years for having 4 baggies of heroin in his pocket. In June, we held a rally for a 22-year-old boy who died from medical neglect in a jail. He had the smallest, amount of drugs possible that he was charged for, criminal possession 7th, and he died in a jail cell for it. The little brother of one of our staff members is currently facing 15 years in prison for a quantity of drugs that could fit in a small lady's purse. These are criminals. Why should they be entitled to our sympathies? Another Richard Sackler email quote. In 2012, 259 million prescriptions were written for opioids, which was more than enough to give every American adult their own bottle of pills. But we've seen no intent to sell, no drug distribution, and no incarceration for the Sacklers. In 2018, Richard Sackler obtained a patent for a medication that can be used to treat opioid addiction. The patent application notes the addictive qualities of opioids. I watched a congressional hearing in December where I saw members call the Sacklers the most evil family in America. And I had hoped that the mass destruction that was caused by this family was being exposed in a way that our lawmakers would get to work on ensuring a plan of accountability. Somehow, the Sacklers are free from the drug war. They walk away unscathed, uncharged for mass murder. They have changed and impacted our country for generations. They even get to keep the money they accumulated as a result of it, leaving the burden and expense on the American people. New York State Attorney General Letitia James shown that the family has withdrawn $11 billion from Purdue Pharma, protecting their wealth from lawsuits. And these slippery suckers found a way to not only suck this wealth off the top of the corporation, they now found a way to protect the wealth they amassed on the graves of our kid, a little loophole called the non-debtor's release. It is likely that less than 2% of us who have lost a loved one will even receive any settlement, not even enough to cover the funerals of our children. What I'm asking you to do today is to please close this loophole that exists.
Thank you so much, Ms. Booth. Now recognize Professor Levitin for 5 minutes.
Mr. Chair Cicilline, Ranking Member Buck, members of the committee, and particularly my own representative, Jamie Raskin. Good morning. My name is Adam Levitin. I'm a professor of law at Georgetown University. I'm here to tell you that Chapter 11's got some problems. They're perhaps best illustrated by what's going on in Purdue Pharma's bankruptcy. Purdue, of course, is the manufacturer of OxyContin, a powerful opioid that played a central role in the opioid crisis. In a couple of weeks, a bankruptcy judge is going to hold a hearing to determine whether to confirm Purdue's Chapter 11 plan. Under Purdue's plan, opioid victims and other creditors, like my own state of Maryland, will be forced to release their claims, not just against Purdue, but also against Purdue's owners, the billionaire Sackler family. The Sacklers will wipe out their opioid liabilities without having to file for bankruptcy themselves. Opioid victims will never have their day in court. The Sacklers will never have to face their creditors, make a full disclosure of their assets, or make all their assets available to creditors. And despite allegedly receiving billions of dollars in fraudulent transfers from Purdue, the Sacklers will actually emerge from Purdue's bankruptcy richer than when they went into it. How did this happen? The key to the Sacklers getting away with it is that Purdue abused the local bankruptcy case assignment rules to handpick the judge for its case. Purdue picked this judge because it knew that he was likely to rule in its favor on all the key issues, including a release of the Sacklers. So far, he is not disappointed. Litigation against the Sacklers has already been stayed for almost 2 years. Now, forum shopping has long been a problem in bankruptcy, but Purdue involves something different. In the last several years, debtors have learned techniques to handpick individual judges whom they believe will rule in their favor. We've gone from having forum shopping among districts to shopping for individual judges. And judge picking reached such an extreme last year that 57% of the large public company bankruptcies ended up before just 3 of the nation's 375 bankruptcy judges. And one of those 3 judges is the very judge who is presiding over Purdue's bankruptcy. Judge picking indelibly taints a case with an appearance of impropriety. What's worse, however, is that appellate review, the critical check on problems at the trial court level, often does not function in bankruptcy. In particular, a doctrine called equitable mootness provides that an appellate court will not reverse a bankruptcy plan that has been substantially consummated in order to protect reliance on the plan. As a result, in many situations, a bankruptcy judge's ruling is the final word. That means once the debtor has picked its preferred judge, it's game, set, and match. This has become the standard operating procedure in big case Chapter 11 practice, and it comes at a price. Sometimes that price is paid by bondholders or landlords, but what we see in cases like Purdue and Boy Scouts of America is that it also comes at the expense of tort victims, of people who have already been terribly wronged. That shouldn't happen. Now, I don't think you're going to hear any defense of judge picking or equitable mootness today. There's recognition across the legal academy and much of the Chapter 11 bar that both are problems that need to be addressed. But I believe you will hear that third-party releases are a useful tool for making the best of a bad situation, and that they should be allowed at least under certain circumstances. I would urge you not to heed that position. The key problem bankruptcy is attempting to address is the orderly payment of claims from a limited fund that's insufficient to satisfy all creditors. That is about making the best of a bad situation. Third-party releases are different, however. They're releases of solvent entities like the US Olympic Committee. So there's no limited fund problem. The only problem is that non-debtors don't want to have to pay their debts. Third-party releases enable them to get a discharge on the cheap by piggybacking on another entity's bankruptcy. And the result is perverse. An insolvent debtor is required to surrender all of its assets, but a solvent non-debtor can get a release in exchange for parting with at most a fraction of its assets. While bankruptcy is about trying to make the best of a bad situation, it's not a license to trample over due process rights. If the Sacklers or any other third party want to resolve mass litigation liability in a single proceeding, they're welcome to file for bankruptcy themselves. But it should be axiomatic that the benefits of bankruptcy relief must go hand in hand with its burdens. I look forward to your questions.
Thank you, Professor. And now recognize Professor Baird for 5 minutes.
Mr. Chairman, Ranking Member Buck, members of the committee, I'm Douglas Baird. I'm the Harry A. Bigelow Distinguished Service Professor at the University of Chicago Law School, and I'm grateful for the opportunity to speak to you today on behalf of the National Bankruptcy Conference. Since 1979, Chapter 11 has saved many thousands of businesses, large and small. As conditions change, however, ongoing vigilance against abuse is essential. And nowhere is vigilance more important than when the rights of those affected are tort victims and involve non-consensual third-party releases. I want to say at the outset that an outright prohibition against third-party releases is one plausible path forward. But it's important to note that taking this course is neither obvious nor compelled. Let me focus on what I think is the hard case. The hard case arises when the debtor has the exclusive right to bring an action against a third party for the benefit of all creditors, including tort victims, and this action dwarfs the value of an independent action that tort victims have against the same party. In many of these cases, the third party is unwilling to settle with the debtor without resolving the other litigation. Settlement with the debtor alone is unacceptable to the third party. Even though the stakes in the other action are comparatively small, without a release, the third party would have to go through the time and effort of litigating many of the same factual issues again. In such a case, the ability to negotiate and implement a global compromise that includes both estate claims and the direct actions of the tort victims can bring about a resolution that produces the best possible outcome in the shortest amount of time. This is appropriate when the settlement enjoys broad support from a vast majority of each class of shareholder, including the tort victim class. Now, it often happens, even when there is widespread acceptance of a Chapter 11 plan, there are holdouts. Overcoming such holdout problems, however, is a standard function of bankruptcy law. Third-party releases in the hands of able professionals and a fair judge can bring about the resolution of a hard case, such as my hypothetical, relatively quickly and on terms that are much better than could be achieved without them. Much depends, of course, on the judge, but this country is blessed with a strong bankruptcy bench. Judges tend to approve non-consensual third-party releases only if a number of conditions are satisfied. Judges are rarely willing to approve third-party releases unless the plan enjoys broad support from a large majority of the tort victims themselves. Judges are inclined to approve a third-party release only when the non-debtor's action against the third party is a small part of the picture, and even then, only when the settlement gives the tort victims as much as they would receive in any other forum. In addition, a strong bankruptcy judge ensures that due process is given and that everyone has the right to be heard. And she also approves releases only when the reorganization could not go forward without them. It should be emphasized that this justification for third-party releases has nothing to do with solicitude for the tortfeasors. They have no right to enjoy any of the protections of the bankruptcy code. They're getting releases only because they can exploit the doubts and uncertainties in the causes of action against them. This gives them the ability to demand releases as a condition of settlement. But of course, this is only one side of the story. There is a risk that permitting such releases gives the bankruptcy judge too much discretion. The multi-factor tests for third-party releases that permeate the case law are themselves a recipe for mischief. For this reason, it is possible and reasonable to conclude that non-consensual third-party releases should be prohibited categorically. Such a prohibition may lead to the liquidation of some businesses and lower recoveries for tort victims in some cases, but this may be a price worth paying if the potential for abuse is too high. The matter, in short, is not clear-cut. As illustrated by the provisions in the Bankruptcy Code explicitly allowing such releases in asbestos cases, something between maintaining the largely directionless status quo and outright prohibition may be the most sensible course. Third-party releases might be explicitly authorized, but only if specific procedural and substantive hurdles are met. Again, the challenges presented by third-party releases, like others facing the bankruptcy system, resist simple solutions and easy answers. As you pursue the hard challenges you face here, the National Bankruptcy Conference stands ready to provide its assistance. Thank you.
Thank you very much, Professor. I now recognize Professor Skeel for 5 minutes.
Thank you for the opportunity to testify this morning. It is a great honor to appear before you. My testimony can be distilled to 2 simple points. First, the danger of abuses in the system is very real, and we've already heard about some of those concerns about abuses. I applaud you for devoting multiple hearings, starting with this one, to investigating these issues. But second, many of the key issues under discussion are complicated and involve provisions or transfers that can be either beneficial or pernicious. In my view, it's very important to take the risk of possible unintended consequences into account before amending the bankruptcy code in these areas. Bankruptcy is designed to provide a collective forum for resolving financial distress. In my view, and here I'm following insights that were first developed by Professor Baird and a colleague, Thomas Jackson, the bankruptcy code generally should not deviate from non-bankruptcy law except where the deviation is needed to provide that collective forum. Otherwise, there may be significant costs and unintended consequences from having 2 different sets of rules, one outside of bankruptcy and one in bankruptcy. The first topic listed for this hearing, and one that we've already talked a great deal about, is non-debtor releases, which are also sometimes called third-party releases. In my view, there are good arguments both for and against non-debtor releases, both as a legal matter and as a policy matter. One argument against non-debtor releases, which we've already heard, is that the benefits of bankruptcy shouldn't be extended to individuals or entities, such as the Sacklers, that are not themselves in bankruptcy. Another argument, which we've also heard, is that it's unfair to release claims that victims or others would otherwise be able to bring in a situation where those victims haven't agreed to release those claims. On the other side are arguments that the treatment of non-debtors such as the Sacklers, that treatment is so closely related to the debtor's bankruptcy case that you really can't resolve the financial distress of the company without also resolving the claims against the non-debtors. It's also possible, and is sometimes argued, that victims may actually, in some cases, receive better compensation in connection with the release than they would be if they litigated against the non-debtors outside of bankruptcy. So what should be done to limit abuses? It seems to me, at a minimum, that a sensible solution might be to insist on more transparency about the non-debtors' assets and ability to contribute, the same kinds of things we expect from debtors in opening their books to be looked at. And perhaps there should be a structured inquiry by the bankruptcy court into the question whether the contribution is significant enough. Another issue on the hearing's agenda is executive bonuses shortly before or after filing for bankruptcy. Once again, bonuses can be pernicious or beneficial depending on how they're used. In my view, the risk of self-dealing, the risk of misusing bonuses, is much more severe if the bonus is given before bankruptcy when nobody's watching than it is once the debtor has filed for bankruptcy, or what are called post-petition bonuses. With post-petition bonuses, there's more transparency, there's a requirement of a hearing, and participants have an opportunity to challenge or to question the bonus. In my view, as a result, pre-bankruptcy bonuses should be viewed with more skepticism than post-petition bonuses, not less. In 2005, Congress enacted a reform that essentially had the opposite effect. It largely banned all post-petition so-called stay bonuses. In my view, this provision has not worked particularly well in practice, and it really underscores the importance of being mindful of the possibility of unintended consequences from legislation. Given the complexity of the issues that we're talking about this morning, my hope is simply that you be especially mindful of potential unintended consequences as you decide which changes or whether to make changes to the bankruptcy code in the coming weeks and months. Thank you.
Thank you, Professor Skeel, and thank you to our witnesses for your opening statements. Before we turn to our round of questions, I'd like to recognize the chairman of the full committee, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Before I begin, I just want to thank the witnesses for sharing their powerful testimony with us today. Today's hearing is the first in a series of hearings examining potential reforms to ensure that commercial and consumer bankruptcy processes function effectively to support the economy, provide a meaningful option of last resort for individuals and businesses, and they're not abused to deprive people of their rights or livelihoods. In 2005, as the ranking member of this subcommittee, I fought against the Bankruptcy Abuse Prevention and Consumer Protection Act, a disastrous amendment to the bankruptcy code that stacked the deck against everyday consumers in favor of creditors and giant companies. Many of the fundamental problems of our bankruptcy system stem from that law, which makes it more difficult for Americans who have fallen in hard times to escape crushing debt. With that in mind, it is essential that we examine a wide range of topics as part of this series. This includes how student loans are treated in bankruptcy, the racial disparities that exist in the use of the consumer bankruptcy system, the rights of workers and retirees in bankruptcy, and the role of the U.S. trustee program. These hearings will explore solutions to help people get a fresh start and a fair deal through the bankruptcy system. Those principles are also at the heart of today's hearing, which will examine corporate misuse of the bankruptcy system, especially a procedure by which wrongdoers can be immunized from liability without agreement from the wronged party in another entity's bankruptcy proceeding. The bankruptcy system is supposed to work for everyone, but in many cases it works only for the powerful. And too often, it works best for big corporations and the very wealthy, who have not even filed for bankruptcy, but who have figured out how to make the system work to their benefit nonetheless. That is exactly what we are dealing with today. Bankruptcy grifters, a term coined by Professor Lindsay Simon that leech off another entity's bankruptcy to hide their misdeeds, silence victims, and secure their ill-gotten gains. As Chairman Cicilline said, today's hearing also builds off the important work of my good friend, Chairwoman Maloney. She has conducted a thorough, tireless investigation of the role of the Sackler family and Purdue Pharma in the opioid crisis. Under her leadership, the Committee on Oversight and Reform has shown the devastating impact that the corporate bankruptcy process can have on ordinary Americans. In particular, she has helped shine a light on one of the most troubling aspects of the Purdue Pharma settlement: the use of a lifetime get-out-of-jail-free card known as a non-consensual, non-debtor release. Under this provision, the Sackler family, who have not had to file for bankruptcy themselves, will escape liability entirely for their role in precipitating the opioid crisis, despite the objections of many of their victims. The families of the people who died from addiction and misuse of OxyContin should be able to hold accountable the people that flooded the country with a dangerous drug they knew would be abused. That is why today I was proud to introduce, along with Senator Warren, Senator Durbin, Chair Maloney, and Chairman Cicilline, the Non-Debtor Release Prohibition Act of 2021. Our bill will ban non-consensual non-debtor releases in most circumstances, impose strict standards for consensual non-debtor releases, and address the use of divisional mergers to shield the company's assets from bankruptcy. I want to thank Senator Elizabeth Warren for our work together to develop this important legislation. She is a powerful advocate for ensuring that the bankruptcy system works for people instead of against them, and I am proud of our partnership on these crucial reforms to the Bankruptcy Code. But most important of all, I want to thank the victims, survivors, affected families, and advocates who have come forward to say that the bankruptcy laws should not be allowed to force anyone, no matter who you are, into giving up their last chance at some semblance of justice against someone grifting off the bankruptcy process. Victims of sexual assault should be able to hold their abusers and the people and institutions that enable those abusers accountable. No one should be coerced into giving up their right to a fair trial before a jury of their peers. No one should be powerless to stop a corporate insider from looting the company they invested in. And no one should be able to evade accountability by gaming the bankruptcy system. Coerced non-debtor releases fall far outside the limited jurisdiction of the bankruptcy courts and are inconsistent with the Fifth Amendment's right to due process of law. Today's hearing is an opportunity to conduct meaningful oversight over this concerning trend and other abuses of the bankruptcy process, and to examine potential solutions to reverse them. I thank Chairman Cicilline again for holding this important hearing. I enjoyed the testimony from our exceptional panel of witnesses, and I yield back the balance of my time.
The chairman yields back, and we will now proceed under the 5-minute rule, and I will recognize myself for 5 minutes. First, I want to say thank you to our witnesses for your testimony, and particularly thank you, Ms. Schweikert-Moser and Ms. Plus, for your really important testimony. And I know every time you are asked to come and share these experiences, it causes you to, again, experience some tremendous pain, but know that it is very valuable for the members of this committee and for the American people to understand that there are real people that are hurt by the current failures in our bankruptcy system. And I'm grateful for your courage and your willingness to come forward and share that with the committee. And I was really struck as I listened to both of your testimonies about kind of how common your experiences sounded. And I wondered, maybe starting with you, Ms. Schweikert-Moser, what about Ms. Plus's experience kind of resonated with you? And similarly, what about Ms. Schweikert-Moser's resonated with you, if you would mind sharing those thoughts?
I think it's the pain, it's not being able to get your day in court, not being able to hold USA Gymnastics and the Olympic Committee accountable, just like Alexis and her son, and not being able to hold the Sacklers accountable. They get to swoop in and barely put any money in the pot, and then they just get off. They're not liable, and they get to go on with their lives. But we're sitting here, holding the bag, holding the pain, and at the end of the day, that's what we have to live with.
Thank you.
I think the situations are so incredibly similar. When we think about corporations, I think a lot of times people in organizations, they think of these decisions not being made by individuals, or there not being a specific person that you can point to the blame of who caused the harm. But certainly in Tasha's case, we can see that there was one perpetrator who very specifically caused these harms and somehow is protected. And it's the same thing with the Perdues and the Sacklers. We see that the Sacklers played a specific role in this. They were the people who caused the harm, just like in Tasha's situation. And yet they found a way to be protected, and that is our laws that are doing that. And it makes all of us feel like there is no justice in this world. And I think that those of us who have survived things like this want to see the world in a different way.
Thank you so much. Professor Levitin, it seems that for large corporate bankruptcies, the Chapter 11 process has markedly diverged from its ideal as bringing parties together to maximize the total return. And you've described a wide-scale breakdown of Chapter 11 bankruptcy's checks and balances. Other observers have warned that Chapter 11 has taken on a Wild West approach that has led to chaos, bankruptcy hardball, and an all-out war between creditors, debtors, and powerful non-debtors. And I'm just wondering, Professor Levitin, how do the abuses that Attorney General Tang have described, Ms. Schweikert-Moser and Ms. Ploutz have described, fit into this broader breakdown of the Chapter 11 process?
Sure. I think there are three key pieces to what's going on. One is that you have a situation in which debtors are now able to handpick the judge for their case. And when debtors are looking for a judge, they don't want a judge who's a great judge. They want a judge who's great for them. Indeed, some debtors' attorneys have told me that they feel they actually have a duty to their clients to try and pick the judge that's best for them. So debtors are hand selecting a judge on the belief that that judge is going to favor them on every key issue. They know that there's not going to be effective appellate review in most instances, in particular because of this doctrine called equitable mootness. And once they have that, that gives debtors free rein to engage in very aggressive restructuring techniques, including non-debtor releases, but there's a host of other practices that they engage in. And they know that there's really no check other than that single bankruptcy judge. And they've picked the bankruptcy judge knowing that the bankruptcy judge isn't going to stand in the way, in part because the handful of bankruptcy judges who are landing the big cases right now, they're actively competing to get these cases. And the way judges are competing to get cases is by indicating that they're going to accommodate debtors' requests. And most bankruptcy judges are not competing, but there's a handful who are, and that's creating a race to the bottom among bankruptcy courts, and it's a real problem.
Thank you, Professor. And before I conclude, I just want to thank Attorney General Tang for his extraordinary leadership and being such a trailblazer in this area, and again, for being here today. My time has expired, and I now recognize the gentleman from North Carolina, Mr. Bishop, for 5 minutes.
I thank the chairman. Professor Levitin, I'm trying to remember, I practiced as a commercial litigator in sort of a small firm, so I represented had a lot of frustrations on their behalf in bankruptcy court over the years. Had some understanding of some of this, and some of it's kind of leaking from my memory. Let me ask you this, if I could, Professor Levitin. If you had, let's say, a concern of some size, I don't know, $100 million in revenues, but they were a client of a huge accounting firm, and there was a basis for alleging that the accounting firm had been neglectful in preparing an audit. And so, as part of the claims of the bankruptcy estate, if that entity was, the $100 million company was in bankruptcy, you could pursue those claims, the trustee or whatever could pursue those claims against the accounting firm. And I assume that one use of this non-party release would be to enter into a settlement with the accounting firm. You wouldn't have a claim to be anywhere near big enough to have any prospect of bankrupting the accounting firm, let's say. But you want to be able to get a recovery from the accounting firm if you can. I assume you'd use one of these non-party releases to effect that settlement. If they were willing to contribute to the bankruptcy estate something to settle that liability, they'd get a release. And I assume that'd be part of the plan, and then it would have to be confirmed by a vote of the creditors, and if somebody objected, the bankruptcy court could use cram down on that one category. Am I right? Would that be one of the uses of this?
So I think it's important to distinguish two different types of releases that are going on, whose claims are being released. It's completely standard and not in any way a problem for the claims of the debtor corporation against that accounting firm to be released. And that's like the claims of Purdue against the Sacklers. So Purdue as a debtor has claims against the Sacklers for fraudulent transfers. Okay. If Purdue wants to settle those claims, that's not this issue. Instead, the issue is when there are direct claims of creditors against the third party. Okay. So if there's a opioid victim who says, I have a direct suit against the Sacklers. I'm not suing Purdue, I'm suing the Sacklers. Right. That's what's getting released, and that's different. Okay, so that's the way the problem.
So that's helpful. So and I remember at the vague edge of my memory, a distinction between claims that can be administered by the bankruptcy court and claims that cannot of creditors. And I guess I think what you're into, and I've forgotten details, but let me pose another example, like of the asbestos cases, where the bankruptcy court creates a massive, perhaps essentially all the worth of a corporation that has been engaged in the sale or distribution of asbestos or manufacture. And they create these asbestos trusts, and then people have been injured by it, and I assume those are the categories of claims you're talking about, have sole recourse against the bankruptcy trust and can't go out in the state court and keep suing that entity, I guess. And again, I'm sorry if I'm mangling this some, but would that be precluded? Is that the kind of thing you want to preclude?
Yes, generally. Asbestos cases are different. There's a special statutory provision for asbestos cases.
Yeah.
And one of the implications of that is that it's not allowed in other situations. Yet the asbestos technique has been extended to situations not involving asbestos. But even with asbestos, there's only 4 limited categories of parties that are entitled to a third-party release under that provision. And that it relates to it's the owners of the debtor, officers and directors of the debtor, insurers, and parties that were involved in basically financing the debtor. And they all have, in order to get that release, they have to make a substantial contribution to the bankruptcy estate. That's what's going on now, are not just releases of those parties in exchange for a substantial contribution, but we're getting, it's a standard practice to see releases of all kinds of parties that have made no contribution whatsoever to the bankruptcy estate. This is what's going on in Purdue. There's a laundry list of consultants, attorneys, lobbyists for Purdue.
I get your point. Let me cut you off just because I've got about 30 seconds left, and I want to get one more question to you, sir, because it's been helpful to me. And I know we're going to have a lot of looking into this, but sorry, lost my train of thought. You said about the judges, this ability to pick your judge. What sort of reform could we? It sounds like there's a problem of exercise of discretion. How can we fix that problem if you didn't want to go to the issue of taking this tool out entirely?
Sure, there's an easy fix. Require that all non-subchapter 5 cases under Chapter 11, that's everything except the small business bankruptcies, that those cases be randomly assigned among judges within a district without regard to the divisions within geographic divisions within the district.
Why isn't that?
That solves the problem.
Asking for indulgence. Why isn't that happening now? How are they assigned now?
The assignment varies by district. In some districts, like the Southern District of Texas, you actually have a complex case panel that's only 2 of the 5 judges. So you're getting 1 of 2 judges if you file in the Southern District of Texas. And the other 3 judges, even though they're equally qualified, never see a big Chapter 11 case. Other districts, it's done geographically in some cases. In other places, Arizona says it's just random. Middle District of Florida says it's going to be geographic, but if there's any indication that a debtor is trying to maneuver in front of a judge, it's then going to be randomized. So it really is done on an individual court level.
Thank you. I yield back.
Sounds like a bill there, Mr. Bishop. I recognize the gentleman from New York, Mr. Nadler, for 5 minutes.
Thank you, Mr. Chairman. Professor Levin, you described the problem of judge picking, where I think you said 3 out of over 337 judges get all the big cases. How would you stop this judge picking? What can we do to stop this judge picking?
In the first instance, I think that it would be to require, as I was just saying to Mr. Bishop from North Carolina, that large Chapter 11 cases, or really all Chapter 11 cases other than the small business cases and the individual debtor cases, should be randomly assigned to judges within a district without regard for geographic divisions or complex case panels or the like. Basically, you should have a random draw within districts. It doesn't entirely solve the problem. You do have some districts where there's only going to be 1 or 2 judges, but I think it substantially solves the problem because the judge picking is going on in districts where you have a large number of judges already, and most of those judges are being ignored. And so take your own district. Southern District of New York, most of the cases are going to one particular judge, Judge Robert Drain, who's sitting in White Plains, New York. There are 7 other excellent judges sitting at Bowling Green in the Bowling Green Courthouse in Manhattan. They're not getting the cases. Instead, they're going to White Plains. And if you have, and that's, debtors are doing really incredible maneuvers to manipulate the judicial, the local rule on case assignment there. So cases filed in Westchester County go to Judge Drain. What do debtors do? They rent short-term office space in office
How would we
parks.
prevent this statutorily?
I think that you, I'm not, so the process would probably be best done, handled by the Rules Committee for the courts to have a federal rule of bankruptcy procedure that deals with case assignment, but I assume that you could do this with direct legislation yourself.
Thank you. Ms. Plusa, I hope you have the pronunciation correct. Mr. Schweikert-Moser, Ms. Schweikert-Moser described the USA Gymnastics bankruptcy as a black hole of truth and accountability. Would you say that also describes the Purdue Pharma bankruptcy? And how would banning non-debtor releases help bring truth and accountability to the Sacklers?
Could you repeat the question? I'm sorry.
Ms. Schweikert-Moser described the USA Gymnastics bankruptcy as a black hole of truth and accountability. Would you say that also describes the Purdue Pharma bankruptcy? And how would banning non-debtor releases help bring truth and accountability to the Sacklers?
Yes, absolutely. I would say that the situation is very similar. And what we know, as I mentioned in my testimony, is that Richard Sackler played a direct role, the Sackler family played a direct role in the decisions that were made for Purdue Pharma. And yet, when we see the numbers from this bankruptcy, we see that the settlement is $4.3 billion over 9 years, but the Sacklers were able to take $11 billion off of the top of the company first. So they're walking away with more money in their pockets than the U.S. government. It's not even individuals who are getting this claim. We have to understand that it's mostly the states. It's very few of us who have lost a loved one who will get a claim at all. And most of us sit confused, wondering what...
And how would banning non-debtor releases help stop this?
Say that again, I'm sorry.
How would banning non-debtor releases help bring truth and accountability?
Well, then we would have that $11 billion up front. The $11 billion that the Sacklers took, we would have up front. And so, yeah.
Thank you. Ms. Schweikert-Moser, the bankruptcy process is supposed to be about fairness, about getting a fresh start, and how money is distributed when there is not enough to go around. But of course, the process of holding people accountable for sexual abuse is about much more than money. From what you've seen of the bankruptcy system, do you think it is ever appropriate to force victims of sexual abuse or other misconduct to give up their rights against the third parties who harmed them?
Absolutely not. I think Professor Leviton hit the nail on the head when he mentioned third-party releases, where creditors have direct claims against the debtor. I was abused by Larry Nasser, the team doctor picked by USA Gymnastics and the Olympic Committee, in the Olympic Stadium, in the actual stadium during the Olympics. I have direct claims against the Olympic Committee. They're an entity that has the ability to pay, but they want to abuse the bankruptcy process by forcing victims like me and my other sister survivors to release our claims against them. It's absolutely unfair, and it needs to be stopped.
Thank you. And finally, Attorney General Tong, people who defend the use of coerced non-debtor releases say that they can deliver a bigger settlement in the bankruptcy process, which benefits everyone. What would you say to that argument?
I would say that's clearly not the case. And the threat of being able to abuse this process, that the Sacklers might be able to secure non-consensual, non-debtor releases, that threat looms large over this entire process. And with respect to my colleagues and lawyers for victims and families like Ms. Plusa's family, that threat that the Sacklers might get away with it pushes that number down, right? And so people rush to make a deal because they're worried if they don't make a deal, the judge will cram the deal down and force us to accept releases. And that's one of the real problems with these non-consensual, non-debtor releases.
Thank you. My time has expired. I yield back.
The gentleman yields back. I now recognize the very distinguished gentleman from Louisiana, Mr. Johnson, for 5 minutes.
Thank you, Chairman Cicilline. I just want to reiterate before I start here, we really do appreciate the witnesses coming in. It's not easy to tell your stories, and it's tragic and disgusting, and what else can we say? Thank you for your courage. I practice constitutional law, so bankruptcy law is a new field for me, and I'm trying to wrap my mind around it, so I appreciate all the expertise. There has been a lot of talk about the non-consensual, non-debtor releases, and let me ask a question, maybe Professor Baird. How much scrutiny do these releases get before a plan is confirmed? So, for example, do claimants challenge these releases? Do U.S. trustees ever object, or how common would that be?
Now, again, it depends on the judge, and there's certainly possible for judges not to exercise the kind of oversight they should. The U.S. trustee will typically object. The unsecured creditors committee should object. All the tort victims themselves are parties in interest who have the ability to appear. But again, a large part of the design of the bankruptcy code is to create an environment in which there are negotiations, and the bankruptcy judge has to exercise oversight. And the hard question for you is whether or not there's sufficient direction on the bankruptcy judge and whether or not specific procedural and substantive standards should be imposed in this area in order to ensure that bankruptcy judges do the jobs they're supposed to do. And I do want to emphasize, I agree with Professor Levitin, that we have an extraordinarily capable bench of bankruptcy judges, but just because they're extraordinarily capable doesn't mean that they shouldn't be given direction.
And some of these judges or some courts have barred non-consensual, non-debtor releases, related injunctions. They believe they're unlawful. What's the basis of that conclusion?
The bankruptcy code has specific provisions for asbestos. It is silent with respect to non-debtor third-party releases, except there's very broad language in a section called 105 that gives broad powers to the bankruptcy judge. So the open question on which the circuit courts are split is whether or not that broad discretion includes third-party releases. And as you've heard, there's some policy arguments why, if appropriately used, it's appropriate, but some courts have said, no, that's a bridge too far, we don't want to do it. Again, there's an opportunity to voice a specific view here, whether to ban them outright, whether to permit the status quo to continue, in which most of the circuit courts, the second, especially the larger ones, the Second Circuit, the Third Circuit, the Seventh, permit them. You can keep in place the status quo, or you can corral the discretion. But this is, I want to emphatically agree with what's been said before. This is an area where serious oversight is necessary, and reassessing these third-party releases is something that's very important.
I lived and worked and practiced in the Fifth Circuit, Louisiana, Texas, Mississippi. Where's the Fifth Circuit on this?
The Fifth Circuit has opposed them.
As opposed to. I have just a minute and a half left. I'll yield back, Mr. Chairman.
Will the gentleman yield?
Yeah, I'll happily yield. Sure.
Thank you, Mr. Johnson. I think I might be next, and I wanted to start with this. I mean, the chances that 3 judges would be drawn out of 375 judges 57% of the time is less than 1 in a million. Anyway, so I've got a young mathematician on my staff who's going to give us the exact number of what the chances are that would happen randomly. But of course, it should be random. And I am totally for random assignment. If Mr. Bishop wants to co-sponsor a bill, or Mr. Johnson, I would love to do it with you guys. But let me ask you this. Professor Levitin, my distinguished constituent, why are the judges competing to get the cases? How are they competing? And to what detriment of the public interest?
So why the motivations, I'd have to speculate. I don't know what's driving any particular judge. Remember, most judges do not seem to be competing for large cases, but I think for the handful that are, part of it is that they like being at the center of attention with a big matter, that they'd rather be dealing with They come from large case Chapter 11 practices themselves, and that's the bar that handles the big cases. Those are their people, and they'd rather deal with those lawyers than deal with the local lawn care business or the
Okay,
bride.
how do they compete?
How do they compete? They compete by sending out signals that to debtors that if they file in their court, that the debtors are going to get favorable treatment. And the way that here's an example of how they send out a signal. In Texas, Southern District of Texas has a complex case panel, and it has an advisory panel for that. If you look at who's on the advisory panel, over half of them are not even admitted to practice in Texas. And so they're getting, instead, who's on the advisory panel? It's the heads of major debtor side practices. And it's a way of saying, hey, we're here to listen to you, and our courtroom is ready for you. In fact, one of the Texas judges has even talked about making the court more customer friendly. I'm not aware of courts having
The
customers.
gentleman's time has expired. Regrettably, to the gentleman from Maryland, his time was not next. The chair now recognizes himself for 5 minutes of questioning. Thank you to Chairman Cicilline and, of course, to the ranking member, Mr. Buck, and thank you to all of our witnesses. And my heartfelt thanks especially to Ms. Schweikert-Moser and Ms. Plus, in particular for your courageous testimony. We are all profoundly grateful, and we stand with you in this fight for justice. Now, as the member representing the great city of White Plains, I feel obligated to apologize for the behavior of Judge Drain. I myself was the lead attorney on a case that ultimately ended up before him in bankruptcy court. And I associate myself with those of you who have suggested that he is overly solicitous of wrongdoing corporations. As we have heard this morning, the powerful are exploiting the Chapter 11 bankruptcy process. Bankruptcy law is complicated, but their playbook is simple. They harm people for profit, then use bankruptcy law to make the people they've harmed pay the price. With my time, I'd like to discuss another powerful industry that has been exploiting the bankruptcy process, and that is the fossil fuel industry. Fossil fuel companies make their billions by polluting air and water, degrading land, and emitting the greenhouse gases that fuel the climate crisis, often in blatant violation of federal law. Then they exploit Chapter 11 bankruptcy so they don't have to clean up the messes that they've made or make amends to the communities whose health, land, and livelihoods they have harmed. Through the Chapter 11 bankruptcy process, fossil fuel companies can split up their assets and their liabilities, keeping their most valuable assets in one company and offloading their environmental debts to another. Once they've divided up like that, neither communities nor environmental regulators can enforce the payment or cleanup duties otherwise required by law. In theory, these are illegal, fraudulent transfers, but in practice, fossil fuel companies are getting away with them. Since Peabody Energy first pulled this trick off nearly 15 years ago, many of the country's biggest fossil fuel companies have followed suit. In the last 6 years, over 260 oil and gas companies have declared bankruptcy. Since 2012, over 50 coal companies have done the same. Those coal companies alone have exploited Chapter 11 to offload billions in environmental obligations onto the American people. And the EPA estimates that it will cost taxpayers $50 billion to clean up the hundreds of thousands of mines companies have abandoned to protect their profits. While the rest of us are expected to clean up the messes that we make, fossil fuel companies, responsible for environmental destruction on a global scale, are exploiting Chapter 11 to avoid this basic responsibility. Professor Levitin, in your written testimony, you discussed the importance of enhancing remedies for fraudulent transfers like these, including divisive mergers. Could you walk us through your recommendations?
Sure. And so let's do this in two parts. Let's talk about fraudulent transfers generally, then divisive mergers as a second subset. For fraudulent transfer law is among some of the oldest law we have in the United States. It goes back to the time of Queen Elizabeth I. The South Carolina statute is actually the original Elizabethan statute. And fraudulent transfer law covers what's called actual fraudulent transfers. Those are transfers made to hinder, delay, or defraud creditors. And the basic remedy for fraudulent transfers is rescission. You have to give back what you took, right? but that fails to create any disincentive to engage in fraudulent transfers. You get caught with your hands in the cookie jar. You took 3 cookies. The law says you have to put back 3 cookies, except what usually happens is a settlement. You took 3 cookies out and you settle and you give 1 cookie back. You keep 2 cookies. So I think that fraudulent transfer law needs a stronger remedy. It needs to probably have something like treble damages for actual fraudulent transfers. Additionally, there should probably be some light criminal penalty for actual fraudulent transfers, because that will mean that then attorneys cannot advise clients to do this transaction. They'd have an ethical problem of doing it. Right now, attorneys are advising clients, yeah, go ahead with a fraudulent transfer. It's not actually fraud. They feel they can advise this. The divisive merger problem is a flavor of this. It's about a feature of Texas and Delaware law that's being used to end run fraudulent transfer law, because Texas and Delaware law says certain transactions are not transfers.
Professor,
even though that's exactly what.
Yeah, bankruptcy scholars Macy and Salavera have proposed giving regulatory liabilities like environmental cleanup obligations top priority in Chapter 11 proceedings. Could that proposal help?
That certainly could. It would help with one subset. It wouldn't help with every flavor of fraudulent transfer like Purdue, but certainly that would be an option.
Thank you. My time has expired. I now recognize the gentleman from Florida, Mr. Stubbe, for 5 minutes.
Thank you, Mr. Chairman. It would be unwise for Congress to have a knee-jerk reaction to one or a handful of sympathetic cases in bankruptcy. With that in mind, my questions are to Professor Baird and Skeel. If you could speak further about the balances struck in Chapter 11 and how it generally does a good job, and the dangers of changing the system based on 1 or 2 less than ideal outcomes would be dangerous for our country.
If I could go first, the Bankruptcy Code, as designed in 1978, created an effective environment in which thousands of businesses have been able to reorganize. It tries to create an environment in which parties are brought together, and it has had a remarkable track record. I think the challenge that you need to think about is not particular cases, not particular pathologies, but rather changes in financial structures, changes in the players of the bankruptcy process, innovations in the various devices like restructuring support agreements, debtor in possession financing that have evolved over time, and carefully assessing whether more regulation needs to be done in order to ensure the playing field is level and stays level.
And I'd like to discuss the protections and safeguards already in place during Chapter 11 proceedings. As you mentioned in your testimony, much about the current system works very well. Can you talk further about how bankruptcy courts work to ensure that the creditor's interests are protected?
The Bankruptcy Code has a number of substantive provisions. 1129A lists the provisions that say this is what's required in a plan of reorganization. The bankruptcy judge has an independent obligation to review that list and ensure that these criteria are actually met. One of those criteria, for example, is something called the best interest test that requires that non-consenting creditors do at least as well in the bankruptcy as they would do outside of bankruptcy. Again, that's an example of a substantive provision that if the bankruptcy judge applies it rigorously, will protect even those people who don't consent to the plan. That's one example. I could give others if you'd like.
Mr. Skeel, is there anything that you would like to add to that?
Thank you. I'll just add a couple of things. I completely agree with everything that Professor Baird has said. The general comment I'll make is that bankruptcy is designed to bring everything into the process. It's designed to reach a global resolution of the financial distress. It's much broader than prior law was. Under prior law, lots of things would fall between the cracks. That doesn't happen anymore. In addition, there is an enormous amount of transparency in bankruptcy. The debtor basically has to open up all the drawers and cupboards and let everybody look at what's going on with the company. Finally, I would say that any time that the debtor does anything that's out of the ordinary course, anything unusual, there has to be notice and a hearing and an opportunity for creditors and other interested parties to object before it's approved. So it's a very, very transparent process. And on the whole, it has been extraordinarily effective.
Can both of you speak further about how Chapter 11 reorganizations, when conducted properly, have the potential to preserve jobs by keeping companies afloat and in turn helping workers and workforce?
I think if you simply look at vast areas of the economy, whether it's the retail industry, or the airline industry, the automobile industry, I think it's unlikely General Motors or Chrysler would still be with us today if we didn't have an effective Chapter 11. You look at almost every major airline, American Airlines, United Airlines, Delta Airlines, they've all been through bankruptcy. Not simply the retailers you've heard of recently, but Bloomingdale's and Macy's also went through bankruptcy. But again, I wouldn't stop just with the large companies. There are lots of small companies that have reorganized successfully. The bipartisan introduction of Subchapter 5 2 years ago, I think has also facilitated small businesses who tried to reorganize during the pandemic. I think you could point to a lot of success stories.
I'll just add, I completely agree. Our system is better at preserving viable businesses when they're in distress, I think it's fair to say, than any other system in the world. And countries all over the world are trying to replicate the Chapter 11 process.
Just quickly, because I have only a couple seconds left, an issue that gets lost in this discussion, the role of bankruptcy court judges, what would be the impact of legislation that limited judicial discretion?
Well, as soon as you limit judicial discretion, when new things arise, judges can have their hands tied. Now, sometimes hands tying is a good thing. For a judge to be able to see, I just can't do that, may actually facilitate negotiations. But as soon as you tell a judge, this is out of bounds, I think one of the failures of the Chandler Act, an old Chapter X that was replaced, is the judges didn't have enough jurisdiction. They didn't have enough power to decide things. People went to other venues. And as a result, proceedings dragged out and many companies failed. And one of the reforms of the 1978 bankruptcy code was to ensure that you could have one-stop shopping in which a judge would supervise the case, act as a judge in the case, and would have jurisdiction over all the problems that arose in the case. And to the extent you take that away, you're going to introduce problems.
Thank you both for your time today. My time's expired.
The gentleman's time has expired. I now recognize the gentleman from Maryland, Mr. Raskin, for 5 minutes. Votes have been called, so we're going to try to squeeze in one on each side because I know Mr. Benz has a scheduling issue too, so we'll try to do that. You're recognized, Mr. Raskin.
Mr. Chairman, thank you very much. Quick update here. The chances that the same three judges would be drawn 57% of the time out of 375 bankruptcy judges is basically 1 over infinity. I have two different mathematicians came back and said the number is too large to quantify. So we need random assignment of the judges so we don't get the bankruptcy debtors essentially picking their own judges or the judges picking their own cases for different reasons. So again, I hope we can make this a bipartisan commitment on the committee to move to random assignment. I've asked my staff to get going on that right away. Professor Levitin, back to you. But what we just heard in the last set of questions were very abstract and generalized statements about the virtues of bankruptcy. But of course, that doesn't go at all to this separate question of the non-consensual, non-debtor provisions. But when I listen to the witnesses, and I want to get to them quickly, but if you could answer quickly on this, is there anything to the idea that there's a benefit to allowing judges the power to grant protection to non-creditors in a way that's non-consensual to the victims of the underlying corporate misconduct?
No, absolutely not. And I think I cannot point to a case in which a debtor would have been unable to reorganize and would have to liquidate because there couldn't be a release of a non-debtor, right? The bankruptcy system works really well generally, as Professors Baird and Skeel point out, but it doesn't require non-consensual non-debtor releases to do its job. That's just a separate issue, the same way that we wouldn't allow a bankruptcy judge to grant a divorce of the debtor's owner or something like that.
Yeah.
It's just outside of the lane of the bankruptcy court.
I mean, when I first heard that it was even happening, I said, that's not possible. It violates due process. How can they blockade my ability to sue a third party without ever hearing my case or having my ability to state what happened? And that's exactly what happened to Ms. Plouffe and to Ms. Schweikert-Moser. Ms. Plouffe, I was moved by what you had to say, that your family's politically active. I don't know if they're Democrats, Republicans, Independents, something else, but you said you didn't understand the role of corporations. Here's Thomas Jefferson. I hope we shall crush it in its birth, the aristocracy of our money corporations, which dare already to challenge our government to a trial of strength and bid defiance to the laws of our country. So tell us again, Ms. Plouffe, how did you feel your basic rights to due process were violated in your situation? And then I'll give a minute to the other witness.
Actually, I think it's important for people to know that the victims had no voice in the Purdue bankruptcy hearing. Unless you have tens of thousands of dollars available to you for private attorneys, which most of us do not have that available, we spent that keeping our kids alive, we could not bring a claim of our own. And so we are all lumped in together, represented by attorneys that we actually have no access to. We have no access to the process. We have no access to the attorneys. We don't know what our rights are. We receive packets of papers in the mail that I would probably need the professor to read for me. At Truth Farm, we have over 30 families who have filed claims in the Purdue hearing, and that's 30 families who are completely confused about the process and most likely will receive no funds as a result of this bankruptcy hearing.
I mean, that is a tragic situation. Let me come to Ms. Schweikert-Moser. How did the U.S. Olympic Committee get off scot-free when they weren't even a party to the proceeding and you never had an opportunity to state your case against them?
You know, to me, this is an overarching theme of freedom of choice. You know, just like what's happening right now in Tokyo with Simone Biles and Naomi Osaka, you know, they had a choice to prioritize their mental health. And not to go too far off topic, you know, I don't care if Simone Biles, you know, steps foot on the Olympic floor. She is and forever will be the greatest gymnast of all time, and I applaud, you know, the stance she took these past few days. But to bring it back to the matter at hand, you know, I and other survivors did not have a choice in the medical provider that USA Gymnastics and the Olympic Committee made us see. We should have a choice in how we seek justice against these non-bankrupt parties. You know, I'm not opposed to consensual releases and consensual settlements. I'm opposed to cram down releases. You know, this legislation does not prevent agreed or consensual settlements. It's preventing forced ones. This legislation addresses the bailout by bankruptcy and abusive process and allows these third parties to drag their feet and delay and prevent our ability to seek justice. So to reiterate, I do not oppose third-party releases through the bankruptcy process. I oppose non-consensual third-party releases where victims like myself do not have a choice.
Because it's unconstitutional, and I yield back to you, Mr. Chairman. Thank you.
Thank you, Mr. Raskin. I now recognize Mr. Bentz for 5 minutes.
Thank you, Mr. Chair, and very quickly, this is a question for Professor Baird. The court in the Purdue case decided that $4 billion was the most it could negotiate for, and I recall listening with some interest to reports and wondering why the number was so small. Can you explain why this number, in your opinion, was reached when apparently, and what standard was being applied that resulted in such a modest sum, given what we've heard today?
Yes, I'll answer the question, but I want to emphasize that I can't speak to the particulars of Purdue, but let me just explain what the challenge is, you know, for, you know, if you had an aggressive trustee or committee going after the Sacklers. In order to recapture a dividend, you have to show the dividend was made at the time the firm was insolvent, and there's a 4-year statute of limitations. So it's transfers, the transfers that are vulnerable are transfers made within 4 years, and you have to show that at the time of each transfer, Purdue was insolvent. If Purdue had no financial debt, which my understanding is it did not, then you have to show when, at what moment in time, the billions that Purdue had made and that it still had weren't sufficiently large to cover the causes of action against them, brought by states, brought by individual, even though perhaps no suits had yet been filed. Again, I don't know the particulars, but you have to say, okay, in expectation, what was the financial condition of Purdue, and can you show that at the time each and every dividend was made, it was within the statute of limitations, and solvency was shown. Now, again, that's a function of fraudulent conveyance law, and fraudulent conveyance tools can be sharpened and so forth. Statute of limitations can be extended, but that's the technical problem that an independent, aggressive party representing Purdue would face in order to try to recover with the Sacklers. And they end up with $4 billion, which is not a lot relative to their wealth. But it appears that's the judgment they've made about what, given the uncertainties and litigation they face. So again, I can't speak to the particulars, but those are the types of technical challenges that would be encountered.
Thank you, and I wish we had 45 minutes for me to ask you all the proper follow-up questions, but we don't. So, Attorney General Tong, you briefly mentioned about 30 minutes ago the fear, you were talking about the leverage that the trustee and others enjoy, or the fear, I think is the way you put it, that the debtor or the third party has in making whatever settlement it might choose to make. And frankly, I didn't quite catch the choices of what was worse. Can you please briefly explain what you were alluding to?
Yes, and thank you for that question, Congressman. I can answer the previous question because I've been at the negotiating table all along in this process. And the reason why the number is so small is because the Sacklers have known all along that they can get away with this. They have known all along that in their back pocket, there's a very strong possibility in the Southern District of New York in Judge Drain's courtroom that they may get non-consensual, non-debtor releases. So to be very candid, the Sacklers put a number on the table, roughly in the neighborhood of the number that's on the table right now, and they haven't moved over a couple of years of negotiation. They've stuck to this $3-4 billion range because they knew they could hang there. And they also knew that there was a very real risk that the court would go beyond the scope of the bankruptcy, which should be focused on the debtor, on the company Purdue Pharma, and consider the Sacklers' interests when they're not debtors. And this, I think, is the real problem. And going back to Ms. Pluse, the real problem with granting non-consensual, non-debtor releases is we will never get to face the Sacklers in court. We will never put them on the stand under oath and go through the evidence. We will never put them on trial. We will never get the transparency that victims and states deserve. Instead, you've got the Sacklers drafting behind, hiding behind the company, Purdue Pharma, and somebody said piggybacking their way to absolving themselves from liability.
Thank you, Mr. Chair. I yield back.
Gentleman yields back. We will now stand in recess so we can vote, and we will resume immediately after votes. And I ask for the indulgence of our witnesses. Call the committee back to order. I now recognize the gentlelady from Washington, Ms. Jayapal, for 5 minutes.
Thank you, Mr. Chairman, and thank you to our witnesses. Our bankruptcy code presents a last resort to bring indebted businesses and their creditors to an agreement that is fair for all parties involved, including workers, retirees, and their families. But non-debtor corporations and individuals have increasingly abused our bankruptcy code and relied on Chapter 11 to insulate themselves and their fortunes from justice. From the opioid epidemic to product liabilities and sex abuse scandals, wrongdoers evade justice as their victims suffer. Ms. Schweikert-Moser, thank you so much for your advocacy and your courage in helping generations of gymnasts like yourself to pursue justice against the U.S. Olympic and Paralympic Committee, USA Gymnastics, after their failure to take sexual abuse allegations against Larry Nassar seriously and holding everyone involved accountable. Like so many, I am proud to cheer for Team USA in Tokyo, but it breaks my heart that they have done everything we have asked of them. Those tasked with protecting them from harm, from USA Gymnastics to the FBI, have failed to intervene. USA Gymnastics has proposed a new $217 million bankruptcy settlement that 512 of the 517 attorneys representing survivors have said does not allow them to present proofs of specific harms. Why is it necessary for survivors to be able to present their harms individually?
The bankruptcy process, especially for non-debtors like the Olympic Committee, allows them to get away with horrific acts, right? So, I mean, they picked the Olympic team doctor, Larry Nassar. He abused us. I was abused in the Olympic Stadium. They're allowed to come in and put, little to no money in the pot and just escape liability. It all comes down to choice. I didn't have a choice on the medical provider that they made me use, and I should have a choice in how I want to seek justice against the Olympic Committee. I also think bankruptcy allows them to, hide behind the curtain. We'll never find out who, what, where, when, why, who knew what with this whole tragedy that went down. And as a survivor, and I believe I can speak for other survivors, we want answers.
And how important is it for you to be able to tell your personal story in the context of this?
Telling my personal story is obviously, every time I do it publicly, it's very hard. Being vulnerable, especially when it comes to sexual abuse, is traumatic. But, I can't change the past. So if telling my story will help change the future, change laws to protect survivors in current and future generations, I'm willing to do it. And I also believe that telling my story personally is therapeutic. And my goal is to leave my mark on this world and to leave a legacy. And if I can help change the bankruptcy laws to protect survivors and victims of the horrific things that third-party releases do to people, I'm going to do it.
I am so grateful to you for that, and I think that holding abusers and their enablers accountable it's how our justice system should work if we want to deter future instances of sexual abuse. When you and many others came forward and pressed charges, you did it with expectation of holding all bad actors accountable. Instead, without them declaring bankruptcy on their own, they have used USA Gymnastics bankruptcy proceedings to release themselves from liability. Would you explain how releasing actors like Steve Penny, the former national team director, and the U.S. Olympics Committee impacts your right to justice?
It doesn't give me a choice, right? I mean, like I said earlier, I'm not opposed to consensual releases. And if the Olympic Committee and Steve Penny want to file for bankruptcy, then they can. But they shouldn't be allowed to piggyback on the USA Gymnastics bankruptcy for pennies on the dollar, given the liability they had in the situation and the responsibility to protect their athletes and basically get off scot-free.
Again, I'm so grateful to you for speaking up and for making this a cause that you fight for. Professor Levitin, using Chapter 11 bankruptcy proceedings to immunize wrongdoers from lawsuits prevents the courts from understanding the full extent of harm to the many claimants, and it protects the non-debtor's reputation as they move on unscathed to other endeavors without being held accountable. Is this how Chapter 11 is supposed to be used? And if not, what is the intention of this bankruptcy process?
No, this is not how Chapter 11 is supposed to work, and it's not how Chapter 11 used to work. Non-debtor releases were not a practice one saw in Chapter 11 until the Johns Manville asbestos bankruptcy, and that case was an outlier for many years. Then Congress enacted a provision for non-debtor releases specifically in asbestos cases, and those cases have some unique features that suggest that maybe they should be treated differently. But we've seen them expanded since, and to the point that they're just standard practice now. So it's not just a couple of cases that look bad of Purdue and USA Gymnastics. It's the Boy Scouts, it's Harvey Weinstein, it's Catholic Church Diocese, it's Takata Airbags, it's Dow Corning. This is a very standard thing, and it's not just releases, it's also stays of non-debtors of litigation against non-debtors during the course of the bankruptcy. Actually, there was a news headline yesterday in the Wall Street Journal. The Lime Tree Bay refinery in St. Croix in the Virgin Islands, the refinery caused oil to actually rain down on St. Croix, poisoning the water source, which is rainwater. They filed for bankruptcy in Houston, not in the Virgin Islands. And now the private equity owners of the refinery are asking the court to stop litigation against them without having to file for bankruptcy themselves. So this is a very common thing, unfortunately.
Thank you. It really is outrageous, and I'm so grateful to you, Mr. Chairman, for having this hearing. Thank you. I yield back.
The gentlelady yields back.
The gentlelady's time has expired. The chair now recognizes myself, for 5 minutes of questions. I am very thankful for the chair bringing this important hearing to us today. Part of this story is very personal to me. Ms. Plouffe, I'm very sorry about the loss of your son, Jeff, and I know that doesn't take us very far, but I'm certain the whole committee wants to try to lift you up. My own son, Harry, is in long-term recovery from opioid use, from addiction to opioids. 8 years, almost 9 months, but ours isn't everybody's story. As you point out in your own testimony, over the course of about 20 years, a little more than 20 years, 930,000 people have died. I'm sure you're aware of the critical number last year. We were up from a high of 73,000 people dying of overdose to, in 2020, during COVID, 93,331 lost souls. That's 255 people a day. I call that a jetliner a day. This country has to do something to ground that jetliner a day. And that's just the one who overdose and die. There are so many others who are struggling with this problem of addiction fueled, jet fueled, as some of you have used the word, by the Sackler family and others for profit. So I guess my first question is to say we have to humanize these numbers. Under the existing loopholes in bankruptcy law, those responsible for recklessly harming millions of Americans can continue to cause the harm. We're looking for accountability. We're looking for legislation that would make sure you and others get accountability. Without our action, more Sackler families will do this again to others' harm. Can you tell us what would any measure of accountability look like to you, to your family, to your community, to families like yours directly harmed by these bankruptcy loopholes?
Thank you so much, and a huge congratulations to your son. It always gives me hope to hear about recovery. So what justice would look like to us is that treatment would be readily available, that the children who are left behind by this crisis without parents because they lost them to overdose would have funds that would help raise them, that would address the trauma that they went through living with parents who had substance use disorder. I know children who found their parents dead, and these children have this trauma to carry the rest of their lives. No one is addressing these needs. Yes. And this settlement is not even going to be able to touch the generational impact that we're going to see in this country as a result of what the Sacklers have done. Instead, what we're doing is moving this burden to the American people because the cost isn't going away. The cost is multi-generational. The cost to families like mine is grief for life. There's no fix for that. I never expected to receive any money. It has nothing to do with that. It's about justice holding the Sacklers accountable for their direct actions in deceiving the American people to make a profit. And now they're able to walk away with that profit and put that burden that they have left with our society on the American taxpayers. Justice would look like the families that I know who have lost their homes, lost their retirement accounts, lost their children's lives. The Sacklers facing the same sort of fate for their horrific actions, that they would also be suffering, but they haven't suffered. They haven't even had to face families like mine. No. They've never had to be in front of anyone testifying. They don't have to, take an oath of honor that they're going to tell the whole truth and nothing but the truth. They literally are allowed to walk away with their name intact.
Pocketing billions. General Tong, in the remaining time that I have, I know you have worked with my own Attorney General, Josh Shapiro of Pennsylvania, on the Purdue Pharma resolution. Under the current bankruptcy laws following this month's resolution, what you talked about in your opening testimony, what does addressing this crisis look like? How will the funds be distributed? What legislative changes must we make?
This is about treatment and prevention and addiction science, and thank you for starting with Ms. Plus and her experience, because this isn't just about money. It's never been about the money. We have, Josh Shapiro and I, the Attorney General for Pennsylvania, and I and many other state attorneys general have an obligation every day to pursue justice for victims, like the Plus family, like the Taylor family in Connecticut. I was telling Alexis over lunch, I wish I could say that her story was uncommon or extreme. Mike Taylor was a young man who worked on my first campaign for elective office. He got a tennis injury. He played tennis at Villanova, fell into addiction from taking opioids, and we lost him. And there are so many families like these in Pennsylvania and Connecticut and across the country.
I see my time has expired. I thank you both, and I'll take the opportunity to continue the conversation offline if I may.
Thank you.
I now recognize the gentleman from Wisconsin, Mr. Fitzgerald, for 5 minutes.
Thank you, Madam Chair. Mr. Baird, one of the premise for some of the legislative proposals is that the bankruptcy process is broken and that the corporate bad actors oftentimes use the bankruptcies as, reduce wages, slash benefits, jettison pension obligations. I mean, there's a long list, right? So some seem to think that every Chapter 11 filing automatically results in harm to workers or others because of the defects in the bankruptcy code. But it seems to me the case is that the code already has some protections for workers, and unhappiness with outcomes by any given stakeholder, maybe because of how or when a firm enters bankruptcy. Generally, no one is 100% happy with the plan, right? I mean, that's kind of the idea. Could you describe at a high level what protections exist in the code to ensure that workers' interests are accounted for?
Congress passed in the late 1980s two provisions to Chapter 11, 1113, 1114, and what they aspire to do is to create an environment in which the employer and those representing the workers can sit down and renegotiate deals that may need to be renegotiated. And it imposes substantive standards that shows that renegotiations can be approved only when collective bargaining agreements can be rejected, only when it's necessary for an effective reorganization. Now, what we need to recognize is that whenever you put a powerful tool like that in place, it's capable of doing good, it's also capable of doing bad, and we need to constantly revisit provisions like this. For example, there are some cases deciding involving airlines where you have a combination between bankruptcy law and the special set of rules governing airline unions that may have produced some bad results. So I think it's important to revisit these areas, and I think we need to recognize that we do have strong provisions. They have been enabled some collective bargaining agreements to be renegotiated, but it's a powerful tool, and like any other powerful tool, we have to be vigilant.
I don't want to put you on the spot, but also any examples where in the end jobs were saved and, maybe the situation was clearly made better for some of the workers in the long run?
Well, we've had steel cases where the pension obligations and so forth were such that, again, a lot of mistakes were made in the past, but the firm simply wasn't going to continue going forward unless there's a restructure. We also look at the airline industry. The airline industry is an example where we had collective bargaining agreements renegotiated in United Airlines and other cases. In the automobile industry, many of the negotiations took place in the shadow of what might happen in bankruptcy. That's another example. Again, these examples tend to arise in industries when there's been a shift, and somehow you're facing a different set of circumstances, and part of what bankruptcy does is face these new realities. And it's hard stuff, and it's certainly subject to abuse, but I think you can point to these very large industries that are better off as a result of having these tools available.
And I mean, at some point, there's going to be a judge, and he's going to make a determination on stakeholders, and oftentimes, if one of those stakeholders is empowered more than the others, it tends to have an outcome that is not desirable all the time. So
it's the special responsibility of the judge to be vigilant and to pay meticulous attention to due process. And when that doesn't happen in a particular case, it's extremely unfortunate.
Thank you, Madam Chair. I yield back.
The gentleman yields back. I now recognize the gentlewoman from Georgia, Ms. McBath, for 5 minutes.
Thank you, Madam Chair. And I want to thank each of you for being here today. And I especially want to thank Ms. Schweikert-Moser and also Ms. Plews. Just thank you so much for your bravery in coming in, coming forward to seek justice. And like so many Americans, I'm just filled with, pride in our nation's Olympic athletes, in particular, Ms. Schweikert-Moser. Your achievements are just even more impressive in light of the abuse that you and so many of your teammates faced. And the ways in which you and your teammates actually just have continued to speak up and show true courage and leadership is really just a commitment to helping others along the way. And Ms. Plews, I know your fight all too well. And I too am a mother who lost my son. So I know exactly the pain that you feel each and every single day. And I can't thank you enough for the work that you're doing, because you really are working to save lives and to make sure that no other parent is facing the immeasurable pain that you have faced. But I have to say, I'm really deeply troubled by the abuses that we've heard about today, particularly those, which the bankruptcy process has been used to avoid accountability for allowing sexual abuse to persist and for endangering people's lives. Ms. Plews, I'll start with you. When you started your advocacy work, I don't think you had any idea whatsoever that bankruptcy proceedings might pose just all these great hurdles and obstacles to your efforts. And so I know that you've covered a great deal today. I've heard your testimony. I've heard you all, this morning. But is there anything else that you've not been able to say that you want people to know right now, how the system and these proceedings are failing families like yours from getting justice that you deserve.
Thank you so much. I appreciate that, and I'm sorry to hear of your loss as well. Yes, so the fact that the Sacklers never have to face a court themselves is really astounding to me. The fact that the Sacklers never have to face families like mine is astounding to me. When you hear the numbers that are quoted, 930,000 people since 1999, and just last year, over 93,000 lives lost in the United States, we get really lost in those numbers. But the reality is every single one of those people is attached to someone who loved them, and their story is important, and their loss is an incredible loss to our communities and our society. And what we need is for the Sacklers to face that loss, to face those families, to hear those stories, and to see the suffering that they have caused, and then for them to individually pay the price. The fact that they have been able to escape paying the price that they have put on the American people is just, it's absolutely horrific, and there is no justice here.
Thank you so much. And Ms. Schweikert-Moser, I'm going to pose the same question to you as well.
You know, I want justice for the survivors and for the victims who, quite frankly, are hurt by this bankruptcy law. I want transparency and accountability by the Olympic Committee and USA Gymnastics. I no longer want to live in a world where USA Gymnastics and the Olympic Committee values medals and winning over the safety and well-being of its athletes. I think that's why it's so important that Simone Biles and Naomi Osaka, withdrawing and taking the stance that they did at an Olympics or at a major international event to prioritize their mental health and well-being is so monumental. The safety of children and athletes should be the foremost, most important thing for these organizations. And again, I think this issue is broader than just gymnastics. We see the same issue in the Boy Scouts, the Catholic Diocese cases. Children are being abused, and these organizations are not held accountable. There's no amount of money that I or any of the hundreds of other survivors would trade for the injuries as a result of the sexual abuse. Larry Nassar went to prison for his crimes, but what about the institutions who failed to protect us and failed their responsibilities and obligations to us? My lawsuits against the Olympic Committee and the lawsuits of the hundreds of other survivors will deter these failures from ever happening again. The civil justice system will work to prevent another serial pedophile from infiltrating these organizations because these organizations, like the Olympic Committee, will learn to act more responsibly. The Olympic Committee should face liability regarding their direct claims and shouldn't escape liability through this bankruptcy loophole.
Well, thank you to each of you for sharing your stories, and I hope that our reforms can really help the many survivors and families that you represent, and I'm out of time. I yield back the balance of my time.
The gentlelady yields back. I now recognize the distinguished ranking member of the subcommittee, the gentleman from Colorado, Mr. Buck, for 5 minutes.
I thank the chair. General Tong, I wanted to ask you whether, if you would answer briefly, I'd appreciate it, whether venue reform is part of the answer when we're talking about this non-debtors release.
Yes, absolutely. I think it would take a broader view of it.
Professor Baird?
I agree absolutely. I think it's a hard issue, but having 3 judges decide this number of cases is not a sign that the system is working effectively.
Professor Levitin?
Yes, I would agree.
And last, Professor Skeel?
Yes, on this issue of the appointment of individual judges, I agree. It ought to be random within a district.
And I guess I'd ask the 4 of you briefly, perhaps going in reverse order this time. It's amazing to me that it's even constitutional. Does this not raise some sort of due process issues when we're talking about and I consider them victims. I don't consider them claimants of some kind, but when the victims don't have the right to come forward in a more meaningful way. Professor Skeel?
I think it does potentially raise due process issues, and there are a variety of ways you can go at it. Professor Levitin has suggested just banning all third-party releases or non-debtor releases. I think you could also consider a more middle-of-the-road solution that allowed them in some circumstances, but required that victims have their day in court. I think victims' ability to have a day in court is absolutely essential. So both from constitutional perspective, I'm not a constitutional expert, but it seems to me there's some issues there. And from a moral perspective, there absolutely are issues there.
Professor Baird?
Due process is essential in bankruptcy court or anywhere else. And if we're failing on that, that should be something you should change.
Okay. Legally?
Yeah, I think there.
I guess my question is, do we need to pass a law that tells a judge they need to comply with minimum due process requirements?
Again, one of Professor Levitin's point is extremely hard to get appellate review in these situations. It shouldn't be necessary, of course. The question is, is it within your power to do something here to ensure that there is more due process in the case of third-party releases, and it emphatically is.
Well, those of us in Congress think everything's within our power, but hopefully that there are people in the bankruptcy system who are listening today and understand the concerns that are being raised. Professor Levitin, your thoughts?
Yeah, I think there is a constitutional problem here, and in the case of Purdue, there's actually an objection filed by the United States trustee, supported by the Department of Justice, challenging the constitutionality of the non-consensual non-debtor releases. This is the first time I'm aware of that the United States trustee has actually challenged non-debtor releases on a constitutionality ground. And it's an issue that really needs to get decided, I think, at the circuit level. But I think, unfortunately, the bankruptcy court is very likely to confirm the release of the Sacklers, and there's unlikely to be any sort of appellate review because of the equitable mootness doctrine.
And General Tong?
Yeah, I want to thank Professor Levitin for bringing that up, because one of the reasons why the trustee and the Department of Justice oppose these non-consensual, non-debtor releases is because we also have not just a constitutional problem, but a federalism problem. As we all know, the federal government, including its courts, the federal government is a government of limited powers, and they exercise the powers delegated to it by the states. And the states, including the state of Colorado, the state of Rhode Island, and the state of Connecticut, have retained our police powers to hold people like the Sacklers accountable. And no federal judge, as far as I know, and no bankruptcy judge has the power to dismiss a state's sovereign claim when exercising its police powers. And that poses a real federalism challenge here and a constitutional problem when a federal bankruptcy judge purports to dismiss or otherwise eliminate a state's sovereign power to protect its residents.
I thank you. And I didn't mean to ignore either Ms. Schweiker-Moser or Ms. Plouffe, but I wanted to get some of the legal issues out. And I thank both of you very much for your testimony today. And I know it's difficult, and I can tell you that you're making a difference, and I very much appreciate you being here. Thank you, and I yield back.
The gentleman yields back. And I, too, want to say again, thank you to our witnesses, particularly witnesses who traveled in person. I think this has been a really productive discussion and very valuable to the members of the committee. So I want to say thank you again. And before we conclude, I just want to give you, Attorney General Tong, and you, Ms. Schweikert-Moser, and you, Ms. Plouffe, and Mr. Baird, kind of any final thoughts you might want to share with us before we conclude the hearing.
Thank you, Mr. Chairman. Let me just summarize by saying you said in your opening remarks that one of our principal purposes here today in our justice system is to pursue fairness. And it's my job as a state attorney general to pursue justice It's also the job of a U.S. bankruptcy court to do justice. And to let the Sacklers get off scot-free with a few $billion payment that is less than 5% on their money every single year is not just, and it's not fair. And I think at the end of the day, the reason why I oppose this proposed settlement is it's just not enough justice for all the victims, thousands upon thousands of victims across the country.
Thank you very much.
Thank you, Chairman. In summary, my direct claims against the Olympic Committee, with the current existing bankruptcy laws, it takes my direct claims away from me. The foundation of our Constitution includes due process and my right to a jury trial. And I'm enraged that those constitutional rights are being violated as a result of the loophole of the existing bankruptcy laws. I have to believe that the Olympic Committee knows that these loopholes work in their favor, and they're dragging their feet to resolve claims with the survivors that they injured. At this very moment, right now, the Olympic Committee is in Tokyo at the Olympics, making money off the very athletes that they failed to protect. We did not have a choice in the medical provider that USA Gymnastics and the Olympic Committee made us see. And I do believe that we should have a choice in how we seek justice against these non-bankrupt parties.
Thank you so much.
Thank you so much. One thing that I want to mention is that if we take too long with this reform, it won't have an impact on the Purdue hearing at all. And so I appreciate being here today, and I hope that we make a difference for other people in the future for similar issues, because if we don't change the laws now, what we're sending is a clear message to all corporations that what they can do is lie to the American people, cause mass destruction, profit off of it, and go home with all of their money and be protected by the bankruptcy proceedings. And so even though this may not benefit the families who have been impacted by the Sacklers, I think that it's important that we set this precedent. There is a chance, though, that you could also pass the Sackler Act in time to impact the Purdue hearing, which I would love to see. And then the last thing that I wanted to mention is, we have, it seems, two systems in the United States, one that applies to corporations and wealthy people, and one that applies to the rest of us. We have a drug war that's raging on. My son spent time behind bars. Countless families have loved ones behind bars. And yet people like the Sacklers have caused countless deaths in the United States and are walking away not only without time behind bars, but with the riches that they made as a result of it. And I think that we as a nation need to figure out how we can change that so that we don't have two separate systems in the United States, because that's not justice. Thank you so much.
Thank you again. Professor Baird, any final thought?
Oh, I think this hearing has been very valuable, and I think reminds us that our bankruptcy laws, as good as they may be, are in need of reform, and vigilance is necessary. And I'm grateful for the chance to come and talk. And I hope that as you think about these reforms, we can continue to talk and we can continue to try to make the laws better.
Great. Thank you so much. This concludes our hearing today. Thank you again to our distinguished witnesses. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. I also seek unanimous consent to add a number of letters and statements regarding the proposals to repair our bankruptcy code discussed here today to the record. Without objection, it's so ordered. This hearing is adjourned.